Welcome to CRIM Law, Episode 10 of the Zech Support Legal Studies series. Today we're diving into a fundamental concept in criminal law, defenses. What they are, how they work, and why they matter so much in trial strategy. So, what exactly is a defense? According to California law, it's any set of circumstances that could prevent a conviction. And here's the key. A defendant can raise multiple defenses even if they seem inconsistent. Why? Because at the end of the day, it's about creating reasonable doubt. Let's break this down into three major categories. Number one, failure of elements defense. We'll call these FAEDs. This one is all about poking holes in the prosecution's case. The defense might argue, hey, the government hasn't proven every required element beyond a reasonable doubt. Think of defenses like mistake of fact, accident, or alibi. These are FAEDs because they challenge whether the crime actually happened the way the state claims. Number two, affirmative defenses. Here, the defendant says, yes, I did it, but I had a good reason. These are separate from the elements of the crime. Classic examples include self-defense, duress, or insanity. If successful, these defenses don't just reduce charges, they excuse the behavior entirely. Number three, public policy defenses. Sometimes we say, even if you're technically guilty, we're not going to prosecute. This is where stuff like statute of limitations or diplomatic immunity comes in. It's a legal system's way of saying, we're not going there. Now, there's a deeper philosophical divide in law between justification and excuse. A justification means, what I did was the right thing under the circumstances, like defending yourself. An excuse, on the other hand, means, what I did was wrong, but I shouldn't be punished, like acting under duress or being legally insane. And let's not forget the burden of proof. Generally, the prosecution must prove the crime beyond a reasonable doubt, but when it comes to defenses, the rules vary. For some, like self-defense, the defendant must present some evidence, but then the burden may shift back to the prosecution. Others, like duress, often require the defendant to prove the defense by a preponderance of the evidence. The U.S. Supreme Court backed this up in the Dixon case, where a woman argued she bought guns under the threat of her abusive boyfriend. The court ruled she had to prove the duress. The government didn't have to disprove it. So whether it's showing a mistake, justifying your actions, or proving you shouldn't be held responsible, defenses are all about turning the tide in court. One of the more nuanced defenses in criminal law, mistake of fact, can get a little tricky. At its core, the idea is simple. If you make an honest mistake about a fact, not the law, and that mistake means you didn't have the intent required to commit a crime, then you might not be guilty. The law, remember, usually requires a guilty act and a guilty mind. No guilty mind, no crime. Let's bring this to life with a case. Picture Sue. She's out having dinner with friends, checks her white wool coat at a restaurant. After dessert, she's handed a white wool coat and heads home. Turns out, that coat wasn't hers. She gets charged with theft. Now here's the legal magic. Theft requires the intent to steal. Sue didn't intend to steal. She honestly thought the coat was hers, and under California law, that kind of honest mistake, if reasonable, can negate the criminal intent. That is the classic example of a mistake of fact that acts as a defense. But it goes deeper. Whether or not your mistake helps you out depends on what kind of crime you're dealing with. Criminal law breaks intent down into categories: general intent, specific intent, and strict liability, and mistake of fact plays differently with each. General intent crimes, like simple theft or battery, require the mistake to be both honest and reasonable. Specific intent crimes, like burglary or larceny, with intent to permanently deprive, only require that the mistake be honest, even if it's completely unreasonable. Strict liability crimes, there's no help there. No intent is required to begin with, so a mistake won't save you. Take the 1979 case People v. Navarro. The defendant took 4 wooden beams from a construction site. He claimed he thought they were abandoned. The trial court told the jury his belief had to be both honest and reasonable, but the appellate court reversed. Why? Because theft is a specific intent crime. The jury should have been told that even if his belief was unreasonable, as long as it was made in good faith, he lacked the required criminal intent. He didn't mean to steal. Another great case is People v. Miles from 2023. The court clarified that mistake of fact isn't a traditional affirmative defense. It's really just saying, I didn't have the guilty mind the crime requires. So, if someone walks off with a jacket thinking it's theirs, they're not trying to justify their actions. They're saying it wasn't a crime at all because they lacked intent. And this can extend to some emotionally charged crimes too, like rape. Let's talk People v. Mayberry, a California Supreme Court case. Here, the defendant argued that he believed the victim had consented to sex. If he truly believed that, even if that belief was wrong, it might mean he didn't have the intent required to commit rape. California courts say that in rape prosecutions, if there's evidence the defendant honestly believed there was consent, that could negate required mens rea. That's a mistake of fact defense. Here's the wild part. In these cases, both people can be telling the truth. The victim didn't consent, but the defendant genuinely thought she did. Legally, that can be enough to raise reasonable doubt. Let's try another example. Isaiah knocks on a door, didn't get a response, and tried to enter through the back, claiming he thought his cousin lived there. Same principle. If there's enough evidence that Isaiah made an honest mistake about who lived there, and that mistake negated criminal intent, it might be enough to avoid a burglary conviction. But here's the kicker. The defendant has to raise the issue. Courts don't just hand out mistake of fact instructions for free. The defense has to produce some evidence that the mistake actually happened. No evidence, no jury instruction. Simple as that. Mistake of fact is like the mental oops defense, but only if that oops cancels out the required intent. It doesn't work on strict liability crimes, and it won't help if you just forgot to do something. But if you genuinely misunderstood the facts, and that misunderstanding would make your actions innocent if true, then the law might just give you a pass. Now let's turn to one of the most emotionally charged and legally intricate defenses of all, self-defense. When someone takes a life and claims it was to save their own, the law starts asking some very difficult questions. Self-defense isn't just a gut instinct. It's a structured legal doctrine. In its perfect form, it's a full defense. It wipes out criminal liability. But to succeed, the law requires that 5 elements all line up. First, the defender has to honestly believe they were in imminent danger of death, serious bodily harm, or crimes like rape or robbery. Second, they must honestly believe that deadly force was necessary to stop that danger. And here's the kicker. Both beliefs must also be objectively reasonable. The law doesn't just ask what you felt. It asks what a reasonable person would have felt in your shoes. Third, you can't use more force than necessary. And finally, you can't be the one who started the fight. That last one is huge. It turns what might look like self-defense into something far more legally fragile. This brings us to the case of United States versus Peterson, a textbook example of how self-defense can unravel when you're the aggressor. Peterson didn't just defend himself, he escalated a situation. He went into his house, grabbed a pistol, loaded it in full view, and threatened the man who was already walking away. The court was not impressed. They said that even if Peterson believed he was in danger, he created the danger. And in the eyes of the law, that meant he had no right to kill in self-defense. And then there's the question of retreat. Should you have to walk away? If it's safe. Some states, like California, say no, you can stand your ground. Others follow the model penal code, which says you have a duty to retreat if you know you can do so safely. The debate comes to a head in cases where defenders were in their own homes. This is where the famous castle doctrine comes in. The idea that you don't have to flee your own home from an intruder. But here's the twist. Even that doctrine only applies if you weren't the one who started the violence. Your home may be your castle, but you lose its protection the moment you become the aggressor. And things get even more complicated when we zoom in on intimate partner violence. What about someone who's been abused for years, living in constant fear? The danger may not be imminent in the traditional sense, but it's very real. Courts are beginning to recognize that the standard self-defense framework doesn't always fit these cases. The law is evolving. So when a defendant stands before a jury and says, "I had to do it, I had no choice," the law doesn't just ask if they were afraid, it asks why, and whether that fear was justified, reasonable, and necessary in the moment. Time to explore the idea of imperfect self-defense, where a person believes they're in danger, but that belief turns out to be unreasonable. It's not a full acquittal, but it can mean the difference between a murder conviction and manslaughter. Next is the necessity defense, sometimes called the choice of evils defense. Imagine you're driving without a license because you're rushing someone to the hospital, or you break into a cabin during a snowstorm to avoid freezing to death. You technically broke the law, but to prevent a greater harm, that's necessity. In California, to successfully argue necessity, you need to show you acted in an emergency to prevent significant, imminent harm. You had no legal alternative, that the harm you caused was less than the harm avoided. You believed your actions were necessary, and your belief was reasonable. Starting to see the pattern? If any one of those aren't satisfied, the defense fails. It's a high bar, but it's a powerful argument when it applies. Now, what if someone forces you to commit a crime? That's where duress comes in. It's an excuse, not a justification. You admit you did something wrong, but say you were under immediate threat of death or personal injury if you didn't. This was the core issue in United States versus Contento Pachon. I could be saying that wrong. The defendant swallowed balloons of cocaine and smuggled them into the U.S. Why? A drug trafficker had threatened to kill his wife and child. The traffickers knew his family's names, where they lived. Contento Pachon argued he was under duress. He had no choice. The court said duress requires 3 elements: an immediate threat of serious bodily injury, a well-grounded fear the threat would be carried out, and no reasonable opportunity to escape the harm. The government pushed back, saying he wasn't restrained, he could have gone to the police, but the defendant said he didn't trust the police in Colombia. They might have been working with the traffickers. The court agreed this was a tribal issue. In other words, a jury should decide. There's also a fourth factor courts sometimes consider: whether the person tried to turn themselves in once safe. In prison escape cases, this matters a lot, but in cases like Contento Pachon's, it's more about whether you truly had no safe way out. These defenses all walk a fine line between law and morality, between what's legal and what's human, and courts are constantly trying to make sense of the messy middle. Now we're going to get into some complicated things. In January 1985, Santa Monica, California, a 32-year-old Japanese woman named Fumiko Kimura takes her 2 young children to the beach. She walks into the ocean, cradling them in her arms. The children die. She survives. To the American legal system, this was a tragic but clear case of murder-suicide, or at least attempted filicide. But within the Japanese community, this act was understood differently. There's a name for it: oyako shinju, a parent-child suicide, often a response to shame, dishonor, or unbearable emotional distress. A mother who commits suicide and leaves her children behind is seen in traditional Japanese culture as someone who has abandoned her children to the disgrace of orphanhood. The community rallied for Kimura, urging the courts to view her act through a cultural lens. 4,000 people signed a petition asking prosecutors to apply modern Japanese law, or at least the values behind it, to her case. But the American legal system doesn't recognize a cultural defense. Not officially, anyway. So what happened? Kimura ultimately pled no contest to voluntary manslaughter. Her sentence, 1 year in prison and 5 years probation, a middle ground, somewhere between punishment and compassion. So can culture serve as a defense in criminal law? The shorter answer is no. The long answer is, it's complicated. The cultural defense, as it's sometimes called, isn't codified in California law. There's no statute or instruction that says if a defendant's actions were in line with their native culture, they may be excused. The system takes a when in Rome approach. You're here, you play by these rules. But that doesn't mean culture is irrelevant. In People v. Mawa, a Hmong man from Laos was accused of rape. But in his culture, there was a practice known as marriage by capture. The man takes the woman, often to a family member's house, and they engage in sex. Outward resistance is expected from the woman. That's part of the ritual. But the act itself is not viewed as non-consensual within that cultural framework. Mawa believed he was honoring that tradition. The court refused to recognize marriage by capture as a valid defense to the charge, but instead of pursuing the more serious offense, prosecutors negotiated a misdemeanor false imprisonment plea. 3 months in jail, a $1,000 fine, no rape conviction. So where does this leave us? While there is no formal cultural defense, defendants can, and often do, introduce cultural evidence to explain their behavior, mitigate culpability, or persuade a judge during sentencing. In California, we follow the objective test for entrapment, meaning the focus is on government misconduct, not the defendant's disposition. But that objectively fades fast when culture comes into play. This becomes even more powerful when we shift to the idea of rotten social background. We're going to take some time to talk about Judge David Bazelon, a controversial but respected figure in the 20th century jurisprudence. Bazelon posed a radical question. What if the environment that shapes a person should factor into how we judge their criminal responsibility? He wasn't talking about culture alone. He meant systematic poverty, generational trauma, abuse, discrimination, the compounded forces that mold someone long before they commit a crime. In a dissenting opinion in United States v. Alexander, he coined the term rotten social background, arguing that our criminal justice system can't pretend to be fair if it refuses to acknowledge what shaped the person standing trial. He wrote, "It is simply unjust to place people in dehumanizing social conditions, to do nothing about those conditions, and then to command those who suffer, behave or else." Those are very strong words, but also deeply polarizing. Legal scholar Stephen J. Morse pushed back, calling this the twilight of welfare criminology. He feared that if background became excuse, criminal law would collapse under the weight of relativism. Everyone has pain, everyone has context, but law, Morse argued, is about action, not explanation. Still, Bazelon's ideas didn't disappear. In fact, they resurfaced in modern discussions about sentencing, disparities, trauma-informed courts, and youth justice reform. You can see their influence in the way modern judges weigh mitigating factors. It may not be a defense, but it's become part of the equation. There are no easy answers. What we do know is this: the legal system is built around the notion of intent, mens rea, but how we form intent, how we perceive right from wrong, how we understand harm, that's shaped by so many forces beyond our control. And in the case of mental illness or involuntary intoxication, we do let the law bend. We recognize that a person who can't form criminal intent shouldn't be held responsible in the same way. So what about someone whose cultural framework never taught them that their behavior was wrong, or someone whose life was shaped by trauma so deep that survival meant learning violence? The law is often painted in black and white, but in reality, it's just shades of gray. And context is the light we shine to see the difference. Every day, people are asked to make extraordinary decisions about guilt, innocence, and everything in between. That's it for today's episode. Congratulations for making it this far. 10 episodes in, and we have a few chapters left before we wrap up CRIM Law on the Zech Support Legal Studies series. I'll see you here next time for episode 11. Till then, stay informed, stay vigilant, stay on the right side of the law. And when finals rears its ugly head, you can always count on Zech Support.